is a civil case ravaging on civil liability filed by the councils before this Honorable Juror Court of Nile University, holding at Nile University. This is the case between the University of Abuja and Bingham University, number 3087/AB 2002. Are the parties in court today?
Yes.
Councils can now make their appearances.
With profound humility and respect to this honorable court, I am BG Ajibola. Your Lordship, with me here are my learned colleagues, SS Aliyu and EI Abba. Your Lordships, our appearance today is for the first and second appellants. The appellants are in court and we're ready to proceed.
Madam, I have a short response. I'll speak as clearly as possible. With profound respect to this Honorable Court of Justice, I am Abiola Ayodele, lead counsel for the respondents. Lead counsel for the respondents, and I am not alone. Appearing with me are Omolola Olayoye and Jessica Zane. We would be entering appearance for the first, second, and third respondents in this suit.
Are you entering appearance right now or announcing your appearance?
Announcing appearance.
All right. When you address the court, you stand up.
Proper guidance. Announcing appearance.
Thank you. Appellants, what are we here for today?
Your Lordships, the matter before us is an appeal against the judgment of the High Court of the Federal Capital Territory that was delivered.
Before we get into that, what are we here for today?
Okay, we're here an appeal.
Are we here to hear it? Are we hearing the appeal today?
Yes.
All right, so we're here for hearing. Please, before we proceed, let's maintain silence. Let all phones be on silent. All right, you may proceed.
Your Lordship,
The matter before this court is an appeal. The claimant, now appellant, filed for defamation against the words of the first respondent published by the second respondent. At the judgment of the lower court, the trial judge found for the respondent, hence this appeal. Your Lordships, for the purpose of our legal arguments today, we have distilled 4 legal issues. With your kind
We have 2 briefs from your university. There's one, the appellant is Wilson, and the other one, registrar, please stop the time. The other one is Coban Jingles.
yes, Judge.
You signed the 2 of them, correct?
Yes,
The same persons. Okay. Why did you do that?
We're here as counsels both to the first and the second appellant. That's both for Wilson. We filed them differently because the cases border on 2 different issues, one on defamation and the second on intellectual property theft. From the facts that were given to us.
Yes. All right, thank you. We believe you understand why you filed 2 briefs. But just for clarity, um, when you are going to proceed now, because there are two briefs, this is not what happens in court normally, but because of the special nature of these proceedings, this is how it's going to be conducted. There are two. There's one you put Wilson as the appellant. There's another brief you put Coban Jingles as the appellant, possibly because distinct issues or something like that. So what we're going to do, I can notice from the issues that in one, there's one issue formulated. In the other, the remaining three issues are there. So you are not going to be stating first and second appellant the way you did it. On this one, normally, it's Wilson that's here. You're still supposed to list this one there as well. Then you can file a separate brief with different representation if you want. But in this scenario now that you've put it two separately, well, based on the nature of these proceedings, we'll proceed with it as it is. But your time is still going to remain the same. We're not going to give you additional time to argue for the other brief of argument. So we'll just assume that the two are one. Am I understood?
Yeah.
All right, thank you. You may proceed.
All right, thank you very much, Your Lordship. For the purpose of our legal arguments, we have distilled 4 issues. With your kind permission, Your Lordships, allow me to bring to your notice how we intend to bring forth our arguments. On our first issue, whether or not Wilson has a right of action in defamation against Rachel, and the second issue, whether or not Bracketed TV is liable in defamation for broadcasting Rachel's statements against Wilson, I will be bringing forward those arguments. For our third issue, whether any defenses against an action for defamation will avail Rachel with respect to her utterances against Wilson, my first co-counsel, S.S. Aliyu, will be adumbrating on that argument. On the last, whether or not Bracketed TV is liable for the theft of intellectual property, our second co-counsel, E.I. Abba, will be substantiating on that argument. So with your kind permission, my lord, I would like to begin with our first argument. Whether or not Wilson has a right of action in defamation against Rachel. Your lordship, for the purpose of these arguments, it's pertinent that we first of all define the essential ingredients in this issue, which is defamation. Defamation, as defined by the Black's Law Dictionary, is the holding up of a person to scorn, contempt, ridicule in a respectable or considerable part of the society. It further states that publication is the unprivileged publication of false statements against the character of another, which leads to injury or damage. Also, in the case of Esika versus Medolu, 2004, 4 Nigerian Weekly Law Report, Part 864, 468, defamation was defined as any imputation which may tend to lower the plaintiff in the eyes of right-thinking members of the society, generally, and also to cut him off or expose him to hatred, contempt, scorn, or ridicule. Your lordships, the statements made by the first respondent against the appellant, Mr. Wilson, were not just mere statements, they were not trivial. Those statements were carefully thought out, those statements were precise, those statements were directed at the respondents. Your lordship, I would like to refer you to 2.6 and paragraph 2.7 of the statement of facts. It was included there. I'm so sorry. It was stated there, the statement of the first respondent. My lords, drawing inference from the definitions given from the definition of defamation in the Black's Law Dictionary and also in the case of Esika versus Medolu, we can say that the statement of the first respondent was meant or tended to lower the reputation of the appellant, Mr. Wilson. Furthermore, your lordships, there are criteria that are necessary, or there are essential elements that are necessary in proving that defamation has occurred, or for a claimant to successfully prove defamation, there are a list of criteria as stated in paragraph 4.3 of the first issue. First, that those words referred to the plaintiff. Secondly, that the words were published to at least one other person other than the plaintiff. And thirdly, that those words were defamatory. The Apex Courts restated this position in Matilda Aderonke Dairo versus Union Bank of Nigeria PLC and another. My lords, it is on the basis of these statements that the appellant reserves or maintains the right to maintain an action of defamation against the respondent, because from the definition of defamation, those words were defamatory. He was alleged to have been harassing women and stalking women, and in paragraph 2.7, it was stated, or there was a public trial that was carried out on Brekete TV, and he was also given a tag, Wilson the Pervert. Your lordships, defamation exists in two forms, as libel or as slander. Libel being the dissemination of communication in a permanent form, maybe printed documents, newspaper, radio or television broadcast. And slander, on the other hand, is most often done through spoken words or gestures. For the purpose of this argument, your lordship, the issue or the genre of defamation in issue here is libel. And we draw inference from the criteria that has been set by the courts to determine whether a publication is libelous. Those constituents were listed out in African Newspaper Limited versus Siroma. The complete citation is included in paragraph 4.7 of our brief. Those constituents include publication, whether the words complained of were published by the defendants, and whether those words refer to the plaintiff. Again, I would restate that those words were published by the second defendant on a national broadcasting television, Berekete TV. Those words complained of were published by the respondents, both the first respondent and the second respondent, and that those words referred to the plaintiff. He was tagged Wilson the Pervert. It was specifically directed to him, and as a matter of fact, from the facts we were given, he was the only one, he's the only one that we know of that suffered as loss as a result of this statement or these allegations that were made against him. One of which is a billion worth deal which he lost with a foreign corporation. Your lordships, the respondents may be quick to bring up the general practice in relation to evidence being led in defamation through the third party, showing the false publication and its consequential effects. As in the case of UAK versus IBC 2005-17 Nigerian Weekly Law Report, part 955, the citation is contained in paragraph 4.9 of the first issue. It was held there that for a claimant to succeed in libel, there must be proof of evidence by the third party of the effects of the alleged publication on him. However, your lordships would also like to bring to your minds a more recent case which has brought about a more liberal position on the issue, and that is contained also in paragraph 4.9 of issue 1, Ashik versus Meditrust Nigeria Limited. It was held that where the words are defamatory in their ordinary sense, the claimants need prove no more than they were published. He need not call witnesses to prove that they understood the words. In ordinary sense, the allegations made that he was a stalker and that he went about harassing women in their ordinary sense are defamatory. And as such, this case reflects the more recent liberal position that's been taken by the courts, and we apply that this recent position be considered in the determination of this case. Lastly, on issue 1, the Your Lordships, from the Apex Court decision in Oduwale versus West, complete citation is in paragraph 4.8 of the first issue. The Supreme Court in Oduwale versus West held that every libel is of itself a wrong in regard to which the law imputes general damages. Once a claimant proves that a libel was published of him without legal justification, his cause of action is complete and he need not prove that he has suffered any resulting actual damage or injury to his reputation. Such damage is already presumed. This was the position of the Apex Court, Your Lordship. But the peculiarity of our case is that not only it's the damages, the Apex Court has ruled that the damages are already presumed once the claimant can show that those publications or the publication was defamatory and that it was indeed published. But not only was this the instance, the appellant actually suffered loss as resulting from the allegations or resulting from these defamatory allegations. Like I mentioned earlier, his company Essex Corporation was currently negotiating a takeover deal with Umbrella Corporation. And as a result, as contained in, Your Lordship, I'd like to refer you to paragraph 2.8, where it was contained that following the media trial that the appellant was currently on, Umbrella Corporation pulled out of the negotiation deal, the takeover deal, that would have caused the appellant to become the country's youngest billionaire. With your kind permission, Your Lordship, I'd like to move to our issue number 2. The issue number 2, whether or not Berekete TV is liable in defamation for broadcasting Rachel's statements against Wilson. Your Lordship, I would also want to refer us back to paragraph 4.7, where the constituents in proving libel is contained. Publication, that the words complained of were published by the defendant, and those words referred to the plaintiff. So, going by these constituents that were distilled by the courts, we can see that Berekete TV, being the second respondent in this issue, are indeed liable for broadcasting Rachel's statements against Wilson. They are according to the facts, they are a popular national television station. We believe that before the term popular was attributed to them, they must have been efficient in some sense. We also believe that for an efficient broadcasting station, there should be standards and protocols as to what should be published on air or what should be broadcasted. We also believe that when a guest and interviewee comes on air and makes these allegations, it beholds on the broadcasting station to confirm to confirm if the statements were actually true before going ahead to either publish it or release it to the public or further making comments on it. But it didn't stop there. They didn't just stop at the interview with the first respondent. According to paragraph 2.6, Your Lordship, paragraph 2.7, a media trial was conducted. In this media trial, on prime time, on the TV station's prime time, viewers were asked to vote as to why, they were made to vote to decide whether Wilson should be allowed to get away with harassing women. Your Lordship, when this kind of vote or when this kind of voting is allowed or permitted on a popular national broadcasting station, it already implies that they are in support or they are also alleging that Wilson, the appellant, is in fact a pervert, a harasser of women and a women stalker. They affirmed the allegations of the first respondent by also going ahead with this voting. Not only did it stop there, a campaign was started on Twitter with the hashtag Wilson the pervert. All of these, Your Lordship, prove the criteria that were set by the courts in African Newspaper Limited versus Siroma, that those words be published, that the words complained of be published by the defendant, and that those words indeed referred to the plaintiff. I would also like to refer Your Lordships to paragraph 4, paragraph 4.5 of issue 2. The learned Judge Oputa GSC stated and set out that for a claimant in an action for libel to succeed, he has the burden to prove against the defendant. We are not ignorant of the burden on this plaintiff, and as such, we are stating that this burden, yes, okay, sorry, permit me to rephrase. The onus on the plaintiff in an action for libel is to prove that the defendant published in a permanent form a statement which is defamatory, that the statement referred to him, that the statement was defamatory of him in the sense that it lowered him in the estimation of right-thinking members of the society, it injured his reputation, his office, his trade or profession, and lastly, injured his financial credit. I would like to end at this point on issue 2, and with your kind permission, Your Lordship, prefer the proceedings to my second co-counsel to further adumbrate on the third issue.
With your kind permission, Your Lordship, I would like to address us on issue 3, which is whether or not any defenses against an action for defamation will avail Rachel with respect to her utterance against Lucy. Your Lordship, the submission of the appellant in respect of this issue is based on the act of the respondent's defamatory statement against the appellant. My Lord, permit me to say that the respondent in this matter is not entitled to a defense because of the situation surrounding the utterance of this statement. And my Lord, I will take us through the reason why I said that she is not entitled to a defense. Your Lordship, from logical inference, it is our submission that the defamatory allegations against the appellant were malicious. This inference is drawn from the fact that no further statements were made by the respondent to support or back up the allegations made against the appellant. Your Lordship, I would like to seek the leave of this court to read the dictum of Pat Acholonu in the case of NTA against Babatope, 1996, number 4, Nigerian Weekly Law Report, part 440, 75, Court of Appeal, verbatim administrative. May I proceed? Thank you, Your Lordship. In this case, he defines malice in law as any corrupt motive, any wrong motive, or any departure from truth. It does not mean mere spite, but improper motive to do or assist in doing what no one knows to be wicked or wrong. Your Lordship, in the case of Onwura and others against Umume and another, citations are provided for. It was stated that it was, in this case, the receiving judge provided for the defenses to the thought of defamation. He ruled, and I quote, "There are a number of defenses available to a claim of defamation, which include justification, fair comment, and privilege." Your Lordship, justification, according to Black's Law Dictionary, is defined as an explanation with supporting data, maintaining or showing a sufficient reason in court why the defendant did what he is called upon to answer, particularly in action for libel. My Lord, the statement made by the respondent can clearly be seen that it is unjustifiable because the respondent failed to proffer evidence to support and back up the allegations against the appellant. And my Lord, the allegations cannot be seen exist or be said to be true. Your Lordship, from the facts of this issue before this honorable court, None of the defenses, either justification, fair comments, or privilege, avails the respondent. As in fact, the first respondent made the statement, the second respondent published it, and constant reference were being made to the appellant, including the use of the term Wilson recovered. My lord, it can be seen that the appellant has suffered critical character assassination, including being an object of mockery and ridicule in the society. My lord, due to the gravity, I lay emphasis on the gravity of the allegations laid against the appellant and the subsequent media trial. It is certain that the appellant can no longer be seen as a man of reputable and respectable character in the society any longer. My lord, the appellant can no longer walk around the society and be seen as a man of respect, integrity, and honor. My lord, it is important to know that whenever a defense of justification is being raised in a case of libel, the party raising the defense is understood to be admitting that he published the words complained of, but contend that the words published are true and he is therefore not guilty of defamation. But my lord, in this matter, the respondent did not prove that the allegations she made against the appellant were true. The respondent only laid allegations against the appellant on the national TV without showing proof that he actually did what she's accusing him of. Thank you, my lord.
Okay.
My lord, with the leave of this honorable court, I would like to confer the next issue to my learned colleague, E.I. Abba. Thank you, my lord.
If it pleases this honorable court, I seek leave to address the following issue. The submission of the appellant is in relation to the act of the second respondent making use of the appellant's intellectual property. The issue is whether or not the respondent is liable for theft of intellectual property. To begin with, my lordship, theft of intellectual property can said to have occurred where intellectual property has been exploited without due authorization. Your lordship, intellectual property can be classified into the following: patents, industrial designs, trade secrets, and copyright. Your lordship, the specific intellectual property rights for which the appellant such relief, such recompense of this honorable court is copyright. Your lordships, permit me to define copyright according to Black's Law Dictionary.
The man, go ahead.
Thank you, your lordship. A property right in an original work of authorship, including literary, musical, dramatic, choreography, pictorial, graphic, cultural, architectural, sound recording, fixed in any tangible medium of expression, giving the holder rights to reproduce, adapt, distribute, perform, and display the work. Your lordship, it is clear that the law of copyright seeks to protect authors of such work. I would like to make reference to the case of Adenuga versus Ilesomi Persons, Nigerian Limited, 1991, 5 Nigerian Weekly Law Report, part 189 at 82. The court held that copyright in relation to eligible work was defined as the exclusive right to control, to do, or authorize the doing of any of the acts restricted to the copyright owner. Your lordship, I will make reference to section 1 sub 1 of the Copyright Act, which provides for works eligible for copyright. Permit me to paraphrase, your lordship. We have literary works, musical works, sound recordings, broadcast, artistic works. Your lordship, I would like to make reference to Article 27 sub 2 of the Universal Declaration of Human Rights. Permit me, your lordship. Everyone has the right to the protection of moral and material interests resulting from any scientific, literary, or artistic product for which he is the author. My lordship, from the fact above, appellant has copyright protection in literary and musical works. Your Lordship, literary works in the sense literary works related to the fact is that the respondents use the jingles produced by the appellant, and it is logical to reason that an advertisement jingle will first be written down by the author in a manuscript and thereby recorded, which constitutes musical work. Your Lordship, I will define literary work according to interpretation section 51 of the Copyright Act. Literary works include, irrespective of literary quality, any of the following works or works similar thereto: novels, stories, and poetical works, plays, stage directories, film scenario, and broadcasting script, choreography, computer programs, textbooks, treatises, histories, biographies, essays and articles, encyclopedias, dictionaries, and directories.
Registrar, registrar, sorry, registrar. Were you giving them the notices? 25 minutes. Thank you, counsel. Defendants or respondent, proceed, please.
Thank you, Council. Bow, bow.
Before we begin, we would like to seek the leave of this honorable court to adopt our brief of argument, which is already before you. And we would like you to adopt this brief because, for the sake of time, we wouldn't like to be referring back to the citation, which is already contained in the memorial. Right. Okay. Okay. My lords, my friends in argument have already stated out the brief facts of this case. So, for want of time, my lord, the respondent will be marshalling arguments that prove that the first respondent, the second respondent, and the third respondent are in no way liable for any of the thoughts that have been stated out by the first and the second appellant, in that we are claiming that the respondents are not liable for both intellectual theft and also defamation. My lord, formulated before us are four issues for determination. The first issue being whether or not Wilson has a right of action against Rachel in defamation, which will be handled by my co-counsel, Jessica Zay. The second issue is whether or not any defenses against an action for defamation will avail Rachel with respect to our utterances against Wilson. This will be treated by Omolola. And the third issue being whether or not Brekete TV is liable in defamation for broadcasting Rachel's statement against Wilson. And lastly, whether Brekete TV is liable for intellectual theft. My lord, I'll be handling the third and the fourth issue. I seek the leave of this honorable court to hand over proceedings to Jessica Z to justify the first issue.
I seek the leave of this court to take over proceedings from my lead counsel, Abiola Ayodele, for the purpose of addressing whether or not Wilson has a right of action against Rachel in defamation. My lord, it is the firm contention of the respondent that the first appellant has no case in defamation against the second respondent. My lord, before I furnish this court on the basis of my question, it is important to define what defamation is explicitly. Defamation has been defined by words spoken or published against a person, which is false, capable of lowering the estimation of right-thinking members of the society, and subjecting the person to cruel, harsh hatred, ridicule, and contempt, and also injuring the person's reputation. This was the definition of defamation in Salahuddin versus Okunle. The Black Laws Dictionary also defines defamation in this same way, but adds that the defamation can be either civil or criminal. My lord, counsel recognizes that libel is a subject of contention in this litigation case, which is why it is essential that the elements constituting libel be outlined accordingly. According to Skybank versus Chief Moses Bolani, the court enumerated the three fundamental elements that must be proven in order for libel to succeed.
The first is that the material complained of by the plaintiff must be published. The second is that the material published must be fair to the plaintiff. The third is that the material published must be false. By implication, unless all these requirements have been tackled and unless they have been proven explicitly, a claim in libel cannot succeed or exist. In contending with first respondent's liability for this action, I will be stating that the first respondent's statement did not refer to the first appellant, who coincidentally bears the name Wilson. My lord, it is a major precursor in establishing libel that the statement made must be fair to the plaintiff. This was elaborated in Dalumo versus Sketch Publishing Company, where the court stated that it is not the published statement must be of the plaintiff. The Learned Brothers also corroborated this statement in Isiquenu and Anor and another against Hero when they stated that it is not only for the plaintiff to state that the statement is defamatory, they must also identify themselves as the one the statement is referring to. They must also identify themselves as the one the statement is referring to. My lord, the effect of this is that as much as it is important for us to state, for you to prove the defamation nature of the statement, it is also important that the statement must be proven to refer only to the plaintiff. My lord, it is on this premise that the respondent confidently contends the first respondent's statement by saying that the alleged defamatory words uttered by Rachel had no connection or intention towards the first appellant, who is Wilson of Essex Corporation. The use of the name Wilson does not automatically mean that it refers to Wilson of Essex Corporation. My lord, I pray your indulgence to please briefly refer to paragraph 4 of the statement of agreed facts. I seek leave of this court to read the statement made by the first respondent, if citizen verba. The hashtag #MeToo movement would be a farce as long as men like Wilson, who have stalked and harassed women, continue to enjoy impunity and are not made to feel remorse about their actions. Emphasis, my lord, on men like Wilson. A careful perusal of this statement would reveal the glaring reality that this statement in no way shows no expression, no word that would declare or insinuate or even suggest that the subject of this statement was made to the first appellant. My lords, it would interest you to know that according to Forebears, which is a renowned online website for memes online, the website states that Wilson is the 350, sorry, is the 535th most commonly used name in the whole world. In Nigeria specifically, 53,177 people bear the name Wilson. How then is it possible that the first appellant has conveniently distinguished himself as the person the subject refers to? My lord, my name is Jessica, but I am not delusional to think that I'm the only Jessica in this world. I am definitely not the only Jessica within this family. My lord, if the court continues to hear appellant's case, strictly appellant's case claim in defamation, strictly on a first name basis, this hallowed temple of justice would be reduced to a field of problems and business. This was advocated in the case of Service Press Limited versus Nnamdi Azikiwe, when your Leonard brother stated that the name Nnamdi Azikiwe, the name Ben Azikiwe does not refer to the plaintiff Nnamdi Azikiwe, and as such, he was not able to identify himself as the person, as the defamed person. Furthermore, my lords, it is trite in law that he who asserts must prove. He who asserts must prove. This is the foundation of the legal maxim affirmative non negati in cubic probation is based on, which literally translates to the burden of proof is placed Section 131 and Section 136 of the Evidence Act 2011. My lord, the law is not blind. The law is not ignorant. If the appellant has identified himself as the subject of the statement, then he must do so on a preponderance of evidence, which he has already failed to do at the trial court. That's as established in the Secret of Abuja, which is the reason why we are all here. My lord, considering the first appellant is lost in identity to justify this claim in defamation, and we revert that the claim in defamation is void ad initio. Therefore, counsel submits by stating that since this vital element preceding culpability in libel has not been successfully proven, it remains uncertain that the first appellant has suffered any claim and suffered any damage, or that any of his rights have been infringed upon. Finally, my lord, having canvassed this argument, I state I submit that the first appellant has no cause of action in defamation whatsoever against the first respondent. I seek the leave of this court to hand over proceedings to my co-counsel, Omolola, for the purpose of addressing the second.
My lord, I seek the leave of this honorable court to take over proceedings from my co-counsel, Jessica. My lord, I'll be addressing this court on issue 2, which is whether or not any defense in the claim of defamation will avail Rachel with respect to her utterances against Ruth. My lord, the law is not only a sword but also a shield. It is therefore our humble yet resolute contention that on this issue, that the first respondent is not left defenseless against the claim of the first appellant in this matter. My learned colleague has painstakingly established the fact that the first appellant was not the person that the statement referred to in this issue. It is therefore out of utmost respect to this hallowed temple of justice that we are compelled to justify our statement. However, assuming without considering that there is a valid right of action against the first respondent for the person that the statement was directed at, the defense of justification will shield the first respondent from any liability whatsoever. My lord, the plea of justification has been recognized by the court in the plethora of cases for committing to apply liability. In the court of appeal case of Emmanuel Biti and others, and Friday Ibom Biti, the learned brothers held that anyone who is sued for defamation can raise as a defense the fact that the statement did not refer to the alleged victim and that the statement was true. The defense of justification was also recognized as a valid defense to a claim of defamation in the case of Onwura and others and Uwume and another. It is therefore our humble yet firm contention that the plea of justification avails the first respondent in this matter, as a statement which were directed to Wilson, who is not a party to this matter, was true. This was well established with sufficient evidences and witnesses at the trial court, my lord. My lord, the trial court sat on this matter, carefully evaluated the evidences before him, and weighed them on the balance of probability before giving judgment to the first respondent. The position of the law is crystal clear that a statement can only be said to be defamatory when it is false, as seen in the case of Anya and Unlimited. This was also corroborated in the case of Sketch versus Ajagbam Kefiri, where the court held that a necessary test for determining if a statement is defamatory is if it was a false statement to a man's discredit. My lord, how then can the truth be said to be defamatory? Your lordships, we are not theologians, neither are we oblivious to the place where we have, or even the Bible says that if Bible says that if the foundation be faulty, what can be right? My lord, permit me to paraphrase. If the case of the first appellant is faulty, what can the respondent do? Assuming without considering that the first appellant did suffer a damage as a result of the first respondent's statement, it is a clear-cut case of damnum askew injuria, that is, my lord, a loss without legal injury. It is therefore our humble submission on this issue that the defense of justification absolves the first respondent absolutely of all liability. Therefore, my lordship,
Having firmly canvassed argue on this issue, I accept the leave of this honorable court to transfer proceedings to my co-counsel who addressed the
My lords, my teammates have laid a solid foundation as to why the first appellant isn't the appropriate party to which we have to justify our position. However, since it appears quintessential to the progress of this case that we would be marshalling arguments that prove that the third respondent had the authority to make the publication as if this matter were instituted by the one who the first respondent was referred to. My lords, let me state categorically that before a third party can be held liable for defamation, it must have repeated the publication of a word to another person or a group of persons. My lords, emphasis on defamatory statements. My lords, these are not mere assertions of counsel, but this was the position of your learned brothers in the case of registered trustees of MORC and Awoniyi. My lord, if it is proved that the statement is indeed true, or that the statement did not refer to the plaintiff, or that there is a lawful excuse for the publication, then there can be no claim in defamation. My lord, this was also the position of the court in Okechukwu and UBA PLC and another. My lord, if the court were to hold otherwise, it would be tantamount to building castles in the air. We concede that indeed there was a publication of the first respondent statement by the third respondent. However, we concede only to the extent that these words were defamatory, that these words referred to the plaintiff, or that there is no lawful excuse for the publication. We make this contention based on the ground of qualified privilege. My lord, the third respondent had the qualified privilege to not only receive this information from the first respondent, but they also had the right to disseminate it to the public in the manner in which they did. Qualified privilege has received judicial notice as a defense defamation in a plethora of cases. Permit me to mention a few. In the case of Onwura and others, and Ume and another, your learned brothers at the Supreme Court held that there are a number of defenses available to a claim of defamation, which include justification, fair comment, privilege, which may either be absolute or qualified. Also, in Ayola and Okajuri, it was held that qualified privilege can be pled in cases where the defendant makes the publication the performance of a legal or moral duty which they owe a third party. My lord, in giving more context to what qualified privilege is, permit me to read ipsissima verba the provisions of the Blackstock Dictionary, second edition. My lord, in the Blackstock Dictionary, second edition, privilege was defined as an exemption from liability for the speaking or publishing of defamatory words concerning another based on the facts that the statement was made in performance of a duty, political, judicial, social, or personal. The Blackstock Dictionary went further to state that privilege is either absolute or conditional. My lord, conditional privilege can also be referred to qualified privilege. The implication of these provisions of the court and the Blackstock Dictionary is that qualified privilege exists where the maker of a publication makes it in furtherance of a legal duty, social duty, political duty, or moral duty, and it makes it to a person who has a corresponding interest or duty to receive it. You may be wondering of what concern this information is to us here. However, it will not make sense in a few seconds. The third respondent, Brekete TV, is not only a human rights organization, but also a broadcasting station that addresses political issues, social issues, moral issues, and also human rights violations. They have the civic duty and interest of the public to obtain an information regarding something as delicate as sexual harassment. My lord, to be grossly ignorant, it would be grossly negligent rather on an institution that prides itself as a human rights watchdog to sit and fold its hand regarding an issue concerning and involving human rights violation, especially one that is as pertinent as sexual violation. My lord, our clients, the third respondent, should be commended and not condemned. My lord, it's our contention that the third respondent falls under the ambit of the protection of this defense as outlined by the Supreme Court in the case of Onwura and others, and Onwume and another. My lord, it may even interest you to know that this defense of qualified privilege is even made available to untrue publications. This was the position of your learned brothers in the case of Nigeria Television Authority and Ebenezer Babatope, 1996, 4 Nigeria Weekly Law Report, part 440, 75 at page 6. My lord, in this case, it was held that qualified privilege is a defense to an untrue publication. How much more in this case, where the first respondent's statements were true, as already established by my co-counsels. My lord, what use is a defense when statements are true? My lord, don't confuse us as approbating and reprobating. All we are simply saying is that the first respondent words were true to begin with. However, assuming without considering that it is even false, the defense of qualified privilege will absolutely absolve the third respondent from any liability. My lords, we conclude therefore by stating unequivocally that the third respondent is in no way, in absolutely no way liable for the publication of the first respondent statement, which the first appellant alleges to be against him. My lord, this takes me to the fourth and the last issue, whether bracketed TV is liable for intellectual theft. My lord, please, I pray your name will court soon. Thank you. Thank you, my lord. It's our humble yet resolute contention that the third respondent is not in any way liable for the intellectual theft of the second appellant's jingles. My lord, we concede that the subject of intellectual theft in this matter is actually a copyright. So at this juncture, it will be pertinent for us to establish what a copyright is. My lord, we know that Jura Novit Korea, the court knows the law, but permit us to just briefly restate for the sake of emphasis what copyright is. Copyright is an exclusive right granted to the originator of a creative work for a period. This has received legislative blessings in the Copyright Act 1988. But we also duly recognize that the Copyright Act in Section 1 sub 1 has qualified creators of musical works amongst other work for copyright. Well, permit me to draw the attention of this court to paragraph 6 and 9 of the Statement of Agreed Facts, where the second appellant alleged that the third respondent used its jingles for a commercial advert for one of its programs without its consent. However, what they failed to state was the purpose of the program which the jingles was used. My lords, the word jingles reminds me of a particular song that I love to sing as the festive season right now, Jingle Bells. My lord, you will agree with me that this is one of the most popular Christmas songs. However, you barely see people being sued for copyright infringement. This is not, my lord, this is because this song is now in the public domain and has outlived its copyright protection. We are not saying that the same applies in this situation. However, we are only establishing that the law is not one-sided. And as it serves as a shield, as it serves as a sword, it also serves as a shield, as rightly established by my co-counsel. My lords, fair dealing, which is also known as fair use, according to United States laws, has received cognizance as a limitation to the exclusive right of a copyright holder. The Copyright Act in paragraph A of its second schedule also recognizes this as a defense to liability for copyright infringement, where it stated that the holder of a copyright has no control over the doing of any of the acts mentioned in the said section 6 by way of fair dealing for purposes of research, private use, criticism, or review, or by reporting of current events. My lord, this means that if an unlicensed user produces, publicizes, performs, or even broadcasts a copyrighted work, as long as it does it in pursuance of any of the purposes that I've already stated, then it cannot be liable for intellectual theft. My lord, we are firm once again, but this time with the law being our solid rock, and on this solid rock we stand that the third respondent is not liable for intellectual theft or the infringement of the second appellant's copyrights by using it without its consent. My lord, it is our position that the use of the jingles by the third respondent was used for reporting current events. Not only was it used for reporting current events, it was also used for a non-commercial purpose. It is well established by my humble self that the third respondent is a human rights organization and also a broadcasting station that broadcasts news relating to topical social, legal, moral, and political issues, amongst many others, which are of relevance to the society. My lords, the program which the jingles was used to advertise was made in pursuance of this duty, as the particular program was telecasting news which are of public interest to the society. My lords, furthermore, this program was used for a non-commercial purpose, which in no way negatively affected any existing market value of the copyrighted work and the holder's pecuniary interest. My lord, given the influence of Brekete TV, given the influence of Brekete TV, credit was given to the second appellant, and this credit that was given to the second appellant was capable of even raising any market value to which the copyright had. It would have even earned the owner more economic interest. My lords, my clients should be appreciated. I'm not being given a lawsuit as a token of appreciation. My lords, we therefore humbly submit that the third respondent cannot be held liable for intellectual theft by using the second appellant's work without its consent. My lord, you must conclude by stating, my lord, please would like to briefly wrap up.
Thank you, counsel. Appellant, may proceed with your rebuttal.
To have a few minutes to prepare a rebuttal.
Yeah, absolutely.
Thank you.
Manu, on the intellectual property of the jingle,